I've been with my partner for 12 years. We live together. We have children. We even bought a house. Aren't we basically common law married? A lot of people believe that just living together long enough means you're legally married. But here's the truth. In Wisconsin, common law marriage does not exist. I'm Jeff Hughes, lead attorney at Sterling Lawyers, and in this video, we're going to clear up the confusion around common law marriage, what Wisconsin law actually says, and how it affects your rights if your relationship ends. Now let's start with the basics. Common law marriage is a type of informal marriage recognized in a few U.S. states. Now here's what it usually means. The couples live together for a certain amount of time and they present themselves as married, meaning they may file taxes together, they may call each other spouse, husband and wife, or something like that. But they never had an official wedding or obtained a marriage license. Now in those states, once you are considered common law married, you have the same legal rights as married folks when it comes to property, children, support, and so much more. But in Wisconsin, the bottom line is we do not recognize common law marriage, no matter how long you've lived together, period. You could be together for 30 years, you could raise a family, have a home together, but under the law, you are still not married unless you go through the legal process. This is clearly stated in Wisconsin law and has been upheld many times by the courts. Now, we once had a client by the name of Teresa. Now, that's not her real name for this video, but her and her boyfriend had lived together for 20 plus years. They raised 2 children together. They had joint accounts. They had both of their names on the house mortgage and on the house title, but when they split, she assumed that she would get spousal support. However, because there was no legal marriage, she was not entitled to maintenance under Wisconsin law. Yes, it was heartbreaking, but it was legally airtight. Now, here's where things get really tricky. If you are not married in Wisconsin and you separate, you do not go through a divorce. Now, here's what that means. There is no maintenance. There is no property division under family law, and there is no legal right to each other's retirement accounts. Each party simply walks away with what's in their name or what they can prove they contributed to. But it's not always clean. If you bought a home together or have other shared assets together, you may need to actually go to civil court to sort things out. Now, however, if you formed a legal common law marriage in another state and you move to Wisconsin, Wisconsin will recognize that under the full faith and credit clause of the U.S. Constitution. Now, for example, if you lived in Colorado and you were recognized under their laws as legally married under their common law rules, and then you move here to Wisconsin, Wisconsin will then recognize you as married. But just living in Wisconsin doesn't count. You have to prove that you were common law married in another state before moving here to Wisconsin. Now, when it comes to children, even if you are not married, you still have legal rights and obligations when it comes to children. There is child support, there are custody orders, and there are placement orders that you can get through the paternity court. These are all governed under the Wisconsin Statute 767, and they apply regardless of marital status. But keep in mind, any parent who is not biologically related or who hasn't formally adopted the child may have no legal standing, even if they helped raise that child for years. Now, how do you protect yourself? If you are in a long-term relationship here in Wisconsin, there are 4 things you can do to protect yourself. The first one is to create what's called a cohabitation agreement. Now, this is an actual contract that can outline property rights, financial expectations, and so much more. And it will be recognized under civil law if you execute it correctly. Now, the second thing you can do is put both names on all joint accounts, on the house title, on the mortgage, on the bank accounts, etc. Now, the third thing you can do is establish legal parentage. And for that, you will need to go to paternity court. And finally, the fourth thing you can do is consider marriage, especially if you're expecting the same protections as legally married folks in the event of a separation. Now, being basically married in Wisconsin doesn't count, and assuming that it does could cost you everything. If you're in a long-term relationship and you want to protect your future, talk to an attorney early before the breakup gets messy. In this next video, we'll walk through how Wisconsin divides property in a legal divorce and why title doesn't always matter. Click below and I'll see you over there.